the appellant. When it's here, H there. No, it's not there. Therefore,
The way you pronounce it. For this one.
for the appellant.
Okay, for the appellants.
Yes, sir.
And it's not period. No.
No.
Have you gotten any letter from?
Yes, I think the letter from the respondent.
So let's start with them.
Applying for an adjournment. On the ground that this the witness is indisposed. Witness. Yeah, that's that will close.
What you said that.
Yes, I understand.
Just a minute, President. I think the other issue with our, what is the rest of the system. So that you're on record.
Okay.
I got you up to where you say you received a letter from the respondent counsel asking for an adjournment on the grounds that their witness is indisposed.
Yes, sir. We are opposed to this application.
No. Regulations?
Sir, the defense, the appellant closed this case
on the 18th of 18th of August 2025.
Yeah.
And then there'll be one there, and they opened that defense. They put the defense in on the 8th of September 2025. They got stopped and they applied for adjournment. Since then, it has been application for adjournments. So, okay. Yes, sorry, sir. It's on the 8th of September 2025. I got stock, yes. I got stocks. Got stock and they applied for an adjournment. Got stock and applied for an adjournment. Have been application for adjournments. For instance, on the 13th of October 2025, that's on adjournment. On the 13th of October 2025, the actual adjournment.
13th
of October 2025, the actual adjournment.
Yeah.
And the case was adjourned to the 3rd of November 2025. They were not in court on that day. Responded and witness not in court. No official communication from them. So the court tribunal was unanimous enough adjourn the matter to the 2nd of December 2025.
What happened in November?
They're not in court. Responded and witness not in court. And no communication from them.
I think it's in November that I was asking.
Yes, sir. But that's on the 3rd of November. Yes, they're not in court. And no official correspondence from them or communication from them. Yes, to
adjourn to
yes, to 2nd of December. Yes, 2025. On that day, on the 2nd of December 2025, due to technical issue with the virtual hearing, the case was adjourned to 21st of January 2026.
Let us adjourn to
21st of January 2026. And on 21st of January 2026, they applied for an adjournment.
From December to what date?
It was 21st of January 2026.
Yeah.
The bill of December, but 21st of January 2026, they applied for an adjournment.
Yes.
Although the matter was adjourned to February 19, 2026, court that on the 18th of March 2026, the date when the matter was adjourned from February to March, they were not in court. Yes,
date for December.
19th of February. 19th of February.
So they will in tribunal.
Yes, and they moved their application that was granted by this tribunal. Then on the compared to March, 18th of March 2026. They were not around. They were not the tribunal.
But I don't know.
It was attended to 18th of March.
Right, it was a problem.
No,
That day was a problem.
no, we were here, 18th of March.
When was the problem?
I don't know, we're here on that 18th of, they were not around, right?
No, it was Thursday, Friday.
But we're here, we're here, so after start on the,
We sat.
start on the,
Thursday, Friday. We're not, no.
Because they were not here.
yeah, they're not here, they're not here. They're not in tribunal on the 18th of March.
And we awarded cost.
Yes.
We just awarded that.
No, I'm not here to apply that. I'm not here with that. The cost for 200,000 naira was awarded against.
Have they paid?
No, they are not paid.
They asked you to furnish your account.
I think I'm not on that.
No, you sure?
You will have called, if you're not interested, you will have called.
They can't call you.
Why
would I call you?
It's only in the call.
Okay.
Not the people to have signed them.
They asked you to
Okay,
forward
I
your
will-
account.
We got them. We didn't get them.
They can go to the court.
From March to April.
Yes, on the 14th of April 26. For those that are left, on that day, we had the issue, yes. Where the lawyer that accompanied the respondent counsel appeared. Why he said didn't appear? It is very strange.
The proceedings were virtual.
Yes. He appeared. He appeared with a lady, a counsel. She appeared. She was showing on it. He said he was having issues. He was having issues with his own. Yes, we are in the same office, so to speak, education. Because of the
I think because of that, we said
technical issue.
we said that there must come.
Yeah, this guy is. And the matter was attended to today. So they're asking for an adjournment. This is one adjournment, you know. There's no material before the tribunal. I mean, don't say the content class. There's no really packet for the material. And moreover, it's very interesting to note that this is on the 21st of January 2026. Give them attend for the last time. Okay, which have been on. I mean, okay, on the 3rd of November 2025, the tribunal give them one more adjournment. Then on the 21st of January, for the last time,
When a lawyer says my witness is indisposed, do we have the facts to disagree with him?
So this adjournment is one too many.
It's one too many years, but when the witness is indisposed, is it something we have control over? I don't think anybody. They say we are saying that we should doubt what's your limit.
So we're applying that it should be foreclosed. That's our application.
No, I'm asking, are you saying we should doubt,
No, I mean, okay,
doubt the letter, the content of the letter?
no, yeah, you said it's, okay,
If we are doubting it, do we have any facts? They say we give us facts, the contrary that look, this witness is not in this post.
Because we just saw the witness and I saw it so clearly. And there's even pictorial evidence,
Yes.
you know.
Can we doubt what your colleague has put down?
no, I'm not saying that. I'm not saying that. What I'm saying is that the attorney is coming from, yes,
Exactly.
the attorneys are becoming too many.
Yes,
Yes,
but there's a genuine reason for this adjournment from the letter. That's what I'm asking. If we attack, we should be attacking the letter. We have the history of all these adjournments on our records. So what we are talking about, your colleague has written. Do we doubt the letter? They say we are saying we should doubt the letter. If we have facts contradict it, so we doubt it and we'll go ahead.
Yes, if we are going to evidence down there, this is not correct.
Because they say when is someone is saying this?
So when
I think there's some things that you don't have control over. The government president, I
can leave you very early but
I agree.
You are right, there have been several.
we agree with you.
We.
That's why we have to award that to the
We don't know you collecting.
We said you should pay that money before today's adjournment. And the last time we asked for your account details, we should do it. So it's not their fault.
But that's not an issue. The issue now.
So let's talk on the veracity of the letter for adjournment.
The contrary.
Opposite adjournment from based on the context of the letter. If you can tell us that, look, what he is talking about in the letter is not correct. And if you have the facts contradicting. Because it's even to help your office. Because the case can go upstairs. Some of these things they can say yes. This fair hearing is very nasty.
The tribunal has been very kind enough to have done that. They've given more than enough opportunity to.
We agree with you. We agree with you. We agree with you.
But on the
You
first
should understand our line of business.
Yes, I thought that.
With this letter, can we discountenance this letter for adjournment? If we have to, what are the facts before us? We will discountenance it.
So what be the application? That means that special of the tribunal.
Well, we think we should. We think we should give them this one chance. If they continue to write today's witness is indisposed, if by the time they say counsel is indisposed, we know that now they are playing a trick. Because you can now use previous letters to say, look, this is their style.
It's just a little patient.
You understand?
I don't have an issue.
The no tribunal is flexible.
It's fair hearing. It's fair hearing sometimes.
Can be very.
You give them the latitude until they put themselves down. Implicate themselves.
Even when they appeal.
By their own conduct.
Even when they appeal, the records of proceedings.
We show that look, the attitude of this
is unbecoming.
yes.
So please.
So let's give them the they are suggesting
So they gave some dates.
they are suggesting 17.
No, 17, 18, and 19. They suggested meetings.
Those 3 days they pick them because they have a case tomorrow and they have a case on Friday. So we need this person for those days. I think that's why they are suggesting.
And
You are not for the 17th.
no. 19th is okay. Friday. Yes, on Friday.
It's a Friday. It's for what? The case was for the defense.
It's for defense. Subject to comments of.
We already got it for that Friday.
No, sir.
You can mention.
Subject to comments of.
So what is your concluding submission?
I'm taking the hit on the tribunal.
No, leave the name of the.
So I'm taking, I'm taking the hit on the tribunal.
You were opposing the opinion of them.
Not opposing anymore.
What's your conclusion submission?
Let's put you down.
Okay, in view of the discussion of the tribunal.
We are still trying to bring it.
If you want to discuss
Okay, in view of,
in the light.
okay,
Go
go
on.
on. Okay.
With the solution.
Uh, in the light of the prevailing circumstances, we see. Okay, we concede to granting them their requests. For an adjournment.
Yes.
We suggest okay, we take all of the dates suggested by them, 19th of February, 19th of June, 2026, subject to convenience of the tribunal.
By consent of the parties, this case is further adjourned to the 19th, 2026 for definite defense.
And that means
For that, they adopt another tax. You can know what for the information. Okay. Very good. Can't wait for you.
no problem.
You came and disappear. Your case was number one and you disappeared.
Number 4, let us take with appeal number TAT/SSS/017/2023. Sherborne Global Services Limited versus Aqua State with Samuel Development.
It's long overdue for your. Good enough. Francis.
In the proper respect to the tribunal, my name is Nuruddin Aziz. I appear with my learned friend, Cynthia Okezie. We humbly announce our appearance for the argument. We're also in receipt of a letter of adjournment from
Your bachelor.
Musa. So we're in receipt of a letter of adjournment by our learned friend, Barrister E.M. Bassi, the counsel representing the respondent. He also put a call through to me on the circumstance leading to their absence. Which of the merit of it, we have no objection to their application. I will wish the witness safe recovery. I will, however, wish this will also not lead to the same circumstance we found ourselves when Lawrence was examined and afterwards, it was not implied then.
We won't present that.
And that was enough time. So I Mr. Lawrence. So we're almost obliged. We're almost obliged.
You suggested, what is there?
So they suggested, I think they have 17. 18. Any of those, I think 17 will be convenient, subject to the overriding comments of the tribunal. We already have a date for 16, which hearing might be going on that day. So if we
That's 17.
17,
no, I think we already have a date for 16, which is not like came up yesterday. Yes, then we can.
It was meant for continuation of examination.
Yes, sir. Yes.
Let's
We also urge the court to maybe put it on the record that it should be physical.
I think we did let that.
Yes, on the last agreement, so that the court can restate it to know that they have to be here physically.
No, that order still stands. The system.
Yes. But it's
We
very
don't have to keep
almost obliged, sir.
But consent of both parties is to further adjourn to the 17th February next week for the continuation of presentation of the third hearing at the Tribunal.
I want to like.
If your system is the good.
What is happening?
Everybody new one. Yeah.
Number one, the cost list is appeal number T80/SSF/0165/2025. Vital State Board of Internal Revenue versus Bridge Street Offshore Support Services Limited.
Appearance?
Main position of the Tribunal, PP Agari. The humble appearance is for the appellant, the record, the Balance State Board of Internal Revenue. Almost grateful.
Respondents? Are they available? Are they online?
Yes, it's the next lecture.
Was you, Ibrahim?
No.
Good morning, sir. My name is. Can you hear me, sir?
Your name is,
My name is Wasi Ibrahim. I'm representing Briggs Trade Offshore.
are you representing them as counsel or as a staff?
As a staff, sir.
Okay.
Can we see you? Was you?
Can we see you? Can we see you? Put on the camera.
And let's have your designation again for the company. What is your role in the company, Mr. Wasiu?
My role is I'm the financial controller. Shift it. I don't want
I got it. Yeah.
put it
Yes.
on my.
Mr. Chairman, sir, the business of the Tribunal today is for continuation of cross-examination.
Yes.
And we are ready to continue, subject to the variety commitments of the Tribunal.
Mr. Wasiu. Mr. Wasiu.
Sir, I can hear you, sir.
Yes, this case was adjourned today so that the appellant's counsel can examine you. You know, there were some documents which they should upload. Yes, so the documents have been uploaded, so it's for presentation.
So
Want to say something?
the document, yes, sir. The document was sent via mail to was it TSZ? Yes, it was sent via
We have
mail.
got the document, yes, we got them and they uploaded. They will show you the documents on the screen.
Okay, okay,
Yes, yes.
okay.
So you need to stand up and affirm your oath. Yes, your oath.
Good morning, Mr. Wasiu.
It's not coming.
Good morning. Can you hear me? Please affirm. Can you hear me? Mr. Wasiu, can you hear me, please?
Yes, I can hear you. Please, can you please switch off the mic?
Stand up.
It's just disturbing.
And state your full name.
It's still on the oath.
Huh?
Take your full name.
My name is Wasiu Ibrahim.
You are hereby reminded that you are still on oath.
Sir?
You are hereby reminded that you are still on oath.
I don't understand, sir.
I'm reminding you that the affirmation oath you took the last time, you are still reminded that you are still that oath this time.
I can't hear you, sir. Tell me how to log in.
Okay, now lift up your right hand if you can't get
Ask them, where's his Quran?
This is the Quran which we are about to be administered on oath again. You prefer the Quran, the Holy Bible,
Go sorry on the
or the God of iron, which is the iron, or word of affirmation. Which one would you like to go?
Let me log in. Can you hear me? But I can't hear very well. I don't know. You know what? Please get me a earpiece to you. Give me 1 minute, sir.
Can you hear me, please? Wasi, can you hear me, please?
I can hardly hear you, so I want to make use of an earpiece. Maybe it will be clearer.
Hey, go ahead.
Just give me a moment, sir.
Aziz want to do the program. Aziz, want to hotel program. They are not even attached to the program.
Are you ready, please?
Yes, I'm ready now.
They asked him again about the last quote.
Okay, the last time you were sworn on oath and you opted for Quran. Can you remember?
Yes.
Okay, I want you to state your full name now.
My name is Wasiu Ibrahim.
You are hereby reminded that you are still on that oath that you took the last time.
Yes, I'm hereby reminded I'm still on that vote here.
Thank you. Please sit down.
You can sit down.
Okay. Nice. Let's talk.
Yeah, Gary.
Yes. Yes, Chairman, sir. May we humbly apply that we have a recap from the court record so as to also be properly guided not to repeat the questions that have been asked.
There was a letter, the letter to the Tribunal dated 9th February 2026. A document titled Status Report inherited at 14 hours on Thursday, 25th April 2025, as admitted in evidence and marked as exhibits D and D2 respectively. Then cross the memo. The writing was on oath on the Quran, and then we couldn't move ahead. We couldn't move ahead because it wasn't following. Because the documents you wanted to present.
No, Mr. Chairman, sir. I mean, after that last this one, we had some questions for which he had responded to.
Yes.
So I don't know, so that we don't repeat the same.
Yeah, I think what happened is I didn't read that. I said it was recorded.
They were recording it.
Okay.
They were recording it virtually, so I didn't write.
Ordinarily, we were supposed to have before now applied for the record.
Yes, so if you want to, you would have applied for the record.
And look at
They
it.
didn't note where you got.
You know, that
Please give
I
me
said
pen.
virtual, I wasn't recording.
Yes, yes.
Pen.
I wasn't.
Pen.
They should have your.
Yes, we do. We do have that. Okay.
I think the essence to we adjourn was to present me on that document.
Yes, yes.
That's what we say it should
If
go.
you can, have the document on this, so that. Precisely, sorry, the speech. The second to the last page.
We are only the document is concluded and all to
How many pages?
the document keep from that the only not the one.
This Bible is not good.
Check the document. How many pages?
Tammy.
You uploaded.
Please tell me. Don't
Yeah,
worry.
check it. How many pages?
Okay. Ignore this one. Skip up, please. Skip up. Let's see if we have another one.
I didn't get any.
No, I'm talking to.
That one I uploaded is how many pages?
It's in the thing. You're gonna be. I want to be sure it's very best. This was his last one. Go back. The last thing. So, we don't discuss it. Check yourself through that. Don't worry, we might change it.
I got it. Did you give the many document or you? Okay, why did you give it to them?
Okay, fix it.
This is the document.
Yes, so speak to the.
Second to last page. That's the second page.
Yeah, but not this page. We'll go to the next document. Yes. He segmented the document and sent to us. But when he was printing, okay, binded on, when he was sent the one is sent to us was submitted. So, this is not.
This is one.
Not this one. Where is it? Check the next. Check. Not the doc.
It's not an SPX.
It is.
Is it what?
What is that you're doing?
I don't know. It's all bundled up together and,
Where's the one?
What date is that your document? The document.
the document I want to do. Mr. Chairman, document I want to refer to him is, it's a correspondence between, Big Trade and SPMP
What dates?
on the 10th day of July 2020.
Check any of those documents. Any of them will definitely.
Check this document. This particular one. Well, that way, once you check this. particular document.
And I think the last question they asked was that the that your document dated from
I am on the 7th of the last six, just bring
the
it.
status report, so you have it.
Status report.
7th of the.
That was the last question you asked.
Is that the last page?
No, still go down.
In that process,
Let me close my,
last
let me
question.
have the close my.
I've seen the record there, I'm writing that.
Yes.
He said, that is the document you know.
The video you have. Friday things to them.
Yes, yes, this is what I want.
2020. 6 p.m. Yeah,
We'll go to the second page.
This is the page.
So,
That was the question, Pastor.
Yes,
The first one.
yes, witness. Yes, my Lord, I'm ready to proceed, sir.
huh?
I'm ready to proceed.
What's you? What's you?
I can hear you, sir.
Okay, listen to the counsel now. Lawyer wants to ask you a question.
He's cross-examining you.
Okay, sir.
Yes, witness, look at the document which you provided for us. It is true, this is your document, that's true.
It-
The document dated, the correspondence dated, dated the 10th day of July 2020. Which
Mhm.
appears on the screen. It's your document, that's true.
Okay.
Now, look at the correspondence. The correspondence is
Can you
between-
enlarge it, please?
Okay.
Can you stated July what?
10th July 2020. The correspondence
Okay.
dated. Take it up. Look it down.
That's a new one.
under executions. B and 2. B and D2. B and or D.
What?
B and letters. B and
PID.
bridge train. So
It is not. It is Richard. I can't be.
Big trade.
I don't know if it's a document.
It's attached to an exhibit.
Because 2 documents.
Does that have a? Okay, that's, it was B and D2.
B and D2.
So this one is
B and D1. B and D2.
Okay. Not B, D as in do. As in don't.
Don't.
It's okay, go ahead.
Yes, it should be brought down a bit. So where the apology starts. Now, just.
Yes,
Now, witness.
Yes.
Please-
Yes, I
please
can
look
hear you,
at-
sir.
Yes, please look at one of your documents which you provided to this honorable tribunal.
Mm-hmm.
Yes, it is true that the crux of this document is to intimate your company that First E&P
Mhm.
is interested in retaining the services of some experts which your company supplied as part of your contract with First E&P. That's true.
Yes, we engage expert engineer. That is a foreign expert engineer. They work remotely, not on site.
because it's company that what?
First EMP.
Yes, we Bricks Trade engage G as the technical expert engineer.
That first year. What was the question?
Yes, my question is, it is true that the crux of this document is that Bricks Trade supplied some expert engineers and First E&P wrote to them to intimate them that some of those engineers, they wish to retain some of those engineers.
Okay.
Now,
What was the third piece?
You have not responded.
You said yes. You said yes.
you said yes.
Okay.
Said yes to what?
What was your answer to the question?
I said
You
BRICS
said everything.
trade.
Okay.
This email you are showing me stated that BRICS trade. Please know, first CMP we like to maintain the technical expertise. Yes, we engage a technical expert engineer. That's G. So they are part of our partners, which UK based, and they work remotely on the job, not physical, not on site.
Now,
Not on site. Can you hear me?
Yes, yes.
Okay.
yes. Now, can you remind this honorable tribunal what services BRICS trade provided to first EMP?
It's a technical service which does not require on-site work, just an assessment which does not require any engineers working on site.
What assessment are you talking about? Witness.
It's a wet storage assessment. This has been part of, if you check the proposal document, so it's already stated on the proposal, which was signed by first CMP.
Now, witness.
Wait. What's you?
Sir,
You say what service the BRICS provide to EMP?
I said is a technical service, which was stated on the proposal signed by BRICS Trade and First AMP. The scope of work is there on the document that was sent.
Okay. Yes.
Yes, witness.
Sir,
It is true that there's nothing in any correspondence or in any of your documents, and there's also nothing before this honorable tribunal to show that the engineers you provided and other experts you provided for first EMP worked remotely. There's nothing before this honorable tribunal to show that. That's true.
And was there anything which shows that they work physically on site?
Witness, this is how it works. You must answer the question.
Don't answer.
You don't
answer. Listen, you either answer yes or no. Don't talk back to a lawyer when you're on the witness box. Please.
Okay. Okay, sir. Okay, sir.
The question is this. Do you have any document to give to this tribunal or which you have given to the tribunal that shows that the engineers you hired worked remotely?
I will have to recheck the details of the document that was sent.
Is there any
What's the
document?
So
answer?
it might not be stated on the
Witness.
exhibit that was sent, but the scope of work is not on-site work. That's all I could say regarding
Yes,
that.
what's you?
Sir,
What's you? The question is this. Is there any
Mhm.
document for the tribunal which shows that those technical experts worked remotely?
that's why I said I will have to recheck
But
if
for
there
now,
is
there is
any.
nothing.
But for now,
For now,
there is nothing stating remotely on the document.
Yes, I got it.
Yes.
Okay.
Witness, recall
Sir.
you told Honorable Tribunal earlier on at the material time of the assessment, you were not an employee of Brick Street. That's true.
Yes.
Yes, witness. And
Yes, sir.
actually, when you were when you first gave your testimony, and the last time you were cross-examined, you never mentioned any such thing as remote workers. This is the first time you're stating that your company provided remote workers. That's also true.
Pro
This is the first time you're stating that.
I stated that in initial, probably it wasn't recorded, or probably it must have stated by Mr. Wale.
Goodness.
Wait. You said it was stated.
Yes, we mentioned it in the maybe in the first hearing or second hearing. I remember it was stated that it wasn't a physical, it wasn't on-site contract. It was stated that it was not an on-site contract.
Don't worry, we'll check our records.
Okay,
now,
sir.
Witness,
Sir?
now I'm putting it to you
Okay.
that what you just said is an afterthought, and you have come to mislead this honorable tribunal. Putting it to you.
No, sir.
Yes.
Yes. Witness.
Sir?
Out. Are you aware of that line of business?
Pardon? What did you say?
Are you aware of the line of business of First E&P for which your company, Brick Street, is a subcontractor to? Are you aware of that line of business?
Their line of business. I
You know
didn't get
what?
that part very well. I didn't get that part very well. Do you mean the work
Let
that
me
First
rephrase.
MP does?
Witness.
Okay.
Witness, can I rephrase?
Yes. Please rephrase.
What business is First EMP doing? What is their business?
Okay. So they are into procurement service. They are into offshore service. That's into inspection service, procurement, and all other. So that's what I could say that I know about First AMP.
Which one is all of us?
What is that?
That all of us. What What are the all others? You said all others.
For now, that's all I could say for now, specifically.
So what you are
Procurement,
mentioning,
inspection service.
procurement service.
Inspection.
You mentioned inspection,
Inspection
workshop.
service, project service. So
you remove all of that.
project service, and for
And
now,
what?
that's all I could say specifically. So that I won't mention what they are not into.
Yes, witness.
Sir?
Since you were not present in Bridge Street at the time, at the material time, which is the time of the assessment for which we came to court for, all what you get this court are information that were provided to you. That's true.
According to the documentation that I have in my department.
That's true.
I work according to the documentation I have with me in my department.
All what you told this tribunal witness is based on the documents that are available to you and what you were told. That's true.
Not what I was told. According to the documentation I have,
the available documents before you.
Is based on available documents before me. Yes, I can say that. Based on available documents before me.
Yes, absolutely. Yes, based on the documentation available.
Yes, witness.
Sir.
It is also.
I can't hear you.
It is also true.
Okay,
yes.
okay. I can hear you now. I think the network is okay.
Just a minute, please.
Okay.
It's also true that you cannot independently.
I can't hear you anymore.
It is true that you cannot independently speak to the authenticity information provided to you by way of documentation because you were not present at the material time and you were never on the field. That's true.
Please rephrase. Please rephrase the sentence.
Yes, witness, what I'm saying is it's true that you cannot speak to the authenticity or otherwise of facts contained in the documents provided to you because you were never on the field, you were never an employee at the material time.
Okay.
That is true.
Okay.
Yes, hello.
I was never an employee. According to the documentation, which was signed by both companies, record shows that the documentation is an authentic documentation.
If witness says he assumed office and based on the files, documents in the files,
Yes,
he works based on what is met in the files.
yes, my lord.
How do you expect him to authenticate
No,
the documents?
my
You say he
lord,
cannot,
my lord, the question had,
you say he cannot,
the question had two ambits
you
to it.
cannot independently speak to the authenticity, the information available to you today. Is that not what they're trying to say? He already told you that he worked based on what is found in the file. And you're asking that he cannot speak to the authenticity of those documents in the file. Can he contradict? Can you have oral evidence to contradict
No, my
what
lord.
will happen in the document? So what if I meet the document in the file? I see it and I read what is there, and I believe that is what it is.
Yes, my
I think that is the hanger.
Yeah.
yes, my final question to this witness.
Yeah.
Yes, witness.
A moment, please.
It is also true that you have been provided ample time and opportunity to do your matter as it pleases you. That's true.
Please rephrase.
It is true that you've been provided with ample time.
By who?
You're thinking too much. Witness, you're thinking too much.
No, I'm not thinking too much. I just want to
Witness,
be
you're thinking
clear
too
so
much.
that I don't
There's-
respond. I
There's
don't
nothing in
respond
the
to what
question.
is. So you. So please, maybe be clear. I would like you to be clearer than. So providing ample time. So I just need a clarity. That's all. I mean, please. I just need a clarity, sir.
Opportunity to.
Sir, I can hear you, sir.
What the lawyer is asking is that this tribunal has given you sufficient time, giving you time to do your case.
Not just please, not just time.
But what?
An opportunity to do it.
See, this tribunal has given you time and opportunity to do your case. That the tribunal has allowed you to do your case the way you want to do it.
Yes, sir. Okay. I got it now. Maybe I mistakenly overheard one particular word. So that's why. Yes, sir.
Yes. That was the second to the last. Now, this is the final question. Witness. It is also true. It is true that Bridge Street did not object to Bridge Street did not put up a valid objection to the notices, the demand notices and other notices sent to it prior to coming to this tribunal. That's true.
That's not true. There was letters that was written objecting to the letter written by the Bayelsa State.
Where is that letter?
It's part of what we have sent initially before the first hearing.
Okay, okay.
It's part of what you have document you have sent.
Okay. Yes, correct.
Yes, Mr. Chairman, and members of the tribunal, we leave this witness at that. So we're done with this witness for now. We appreciate the time and the patience of this honorable tribunal. We want to wait, Mr. Chairman.
I think this is there's only okay. Wasu,
Sir,
do you have another witness apart from yourself?
the Mr. Wale,
Brick
he joined, yes, Bricks Trade, he joined the meeting, he joined the proceeding in the morning because it was stated 10 o'clock. So, and so he's unable to rejoin. So that would have been my second witness. So he's unable to join at the moment.
No, what I mean by witness is, you know, you testified, you took you took oaths and you gave evidence.
Okay.
You have another person who wants to give evidence on behalf of Race Trade.
No, I don't have.
Okay.
Probably the Mr. Wale might have, but for me as a I don't have. That's it.
No, I mean
Because
Bricks
it's on
Trade. Bricks Trade now.
brick.
You gave
Okay,
evidence.
bricks trade.
You gave evidence for Bricks Trade, is it not?
Okay, yes.
Is there not any other witness who wants to testify, who wants to give evidence for Bricks Trade?
Okay, apart from Mr. Wale, apart from me, we don't have.
As part.
Mr. Wale is the MD, is he not? Is the MD.
So you didn't come as a
Yeah.
witness. You are the one witnessing for the company.
Yeah.
On behalf of Brick Trade, it is you that is the witness. Are you the sole witness? Mr. Wale is the
Yeah.
MP.
Yes, but he also
How are you
represented to be part of a witness. That's why he actually joined. Eh?
He didn't tell us that. When you went on oath the last time, you want to that out. Now
Okay.
you take last time.
Okay. So because is why I'm saying that is he might, yes, he's the MD and he might as another witness might have. So, but for yes, I serve as a witness while he's the MD. So saying it if Bricks Trade has another witness or not. So what if he has another witness? If I as a witness, maybe I wasn't around at that moment, at that material time that the contract took place.
Hey,
Probably the MD might have.
Wasu.
Sir.
So we'll give you another date if you have a witness. That next day you bring the witness.
Okay.
Right?
Okay, sir.
We'll give you another date. So if you have another witness to support your case, you bring the witness that day.
Okay. Can I ask a question, sir?
Yes.
Okay. If because I will need to reach out to the MD, that's Mr. Wale, if he has. So if he said yes or no, can I send a mail regarding that so that there won't be need for
no,
another?
The
Yes.
next adjourned day, you come and tell us.
You tell us.
Okay. Okay. That's fine. That is fine.
So we'll give you another date.
That is fine, sir.
For continuation of defense.
Okay. That is fine, sir.
1 day.
is, what's you?
Sir,
17th June. 17th June, you come and tell us if you still have a witness.
okay, 17th June.
Yes.
Okay.
This case is further adjourned to the 17th June 2026 for continued affairs. What do you have this?
Number 3 on the course list with appeal number C80/SSS/008/2025. Rice State Board of Internal Revenue versus Lottery Supermarket.
Curtis,
Most respected, Mr. Chairman, and all members of the tribunal. My name is P.P. Agari. My humble appearance is for the appellant of record about the State Board of Internal Revenue. I'm most grateful, my lord.
yes,
The committee most profound to the Honorable Tribunal. I am Nemeka Victor Ngong. I humbly appear in protest for the ostensible respondent.
why are you protesting?
Lord, the placard before the tribunal bears the facts.
Any party rep? No.
No party rep on the
Yes,
part of the
yes, sir. Well, guess what I done? Yes, I got it.
Mr. Chairman, sir, we will be guided by the record of the tribunal so that we will be in doubt as to.
I got it. What is your own record telling you?
The chairman, the record of the tribunal is superior to.
What is your own telling you, if I can correct you? It's not correct.
My record tells me that today was for adoption and.
Adoption of what? Adoption of what?
Appellant's motions
To adopt
to amend. Yes,
To adopt the motion.
yes.
Adoption. Who appeared in this case the last time?
I think I'm just who appeared.
You appeared, and you don't know what the case was adjourned for.
Mr. Chairman, that was a long time ago.
It can be a long time ago. This was just
Next April.
15th of April. What were you coming to? I want to become a step. When do you know that Lucy is coming up with the corporation? Just for adoption of final written addresses.
No, our motions.
Go ahead.
And Mr. Chairman, the respondents served us a further. The respondent served us a counter affidavit in opposition to the appellant's application, which is dated and filed on the 7th day of May. On the 7th day of May, 7th day of May 2026.
Just hold on.
Yes.
Yes, and Mr. Chairman, sir, we felt it was important we address some of the issues really on point of law. The reply on point of law.
Well, there's the issues
raised in this counter affidavit.
Points of law.
Yes, yes, issues of point of law.
So what do you want to do?
Though we suffered a little setback as at it's something that was supposed to have filed.
If it's point of law.
Yes, but I can also address it because
If it's point of law, when you're moving up there, I can address it.
okay.
You want to file something?
We want to file. That was the reason why I was.
You want to file?
Yes.
They served you when? They served you on the 7th of
Yes.
today is 13 days ago, 2 weeks. No, you didn't have 2 weeks. You didn't have time to file.
Mr. Chairman, regrettably, we did not. We suffered certain setback, even the laptop for which.
So there's issues raised in the conduct.
Yes.
One.
Mr. Chairman.
Because for the sensible respondents.
In protest.
In protest. Did you hear your colleague?
I heard him, and I regret such application because it still points to the regret we have expressed severally even in our processes about this appeal. This appeal is merely to drag and punish a person for challenging a process that is unlawful. And the tribunal should not continue to indulge them. This appeal or purported appeal was filed since August last year, and we are still at the preliminary date. And every day they will come to the tribunal and give excuses. Processes served since 7th of May has not been responded to if they want to respond. And I will not be worried if he can respond orally. Let us conclude this part and move on. This matter is taking my time. It's taking my client's time. It's taking our energy. And it ought not to be, because the matter is ab initio incompetent. And we have showed so. And I don't know the amount of compensation the tribunal will be prepared to give us at the end of the day if our points are approved. We have showed that this appeal has no basis at all.
Did you apply for compensation?
In every of our application, we made that with punitive costs. We say dismiss with punitive costs. And this time in our preliminary application, we stated so. They brought application for amendment, we objected and stated so. Yet they are bringing application to arrest a ruling that the tribunal has reserved, which is untenable in law.
No, I hear it.
Take it to.
Yes, ma'am. Yes, madam.
You have 2 weeks to deal. It's up on the 7th.
Yes.
Otherwise,
Yes.
you didn't file anything.
I
If If you have issues of law which you want to respond to,
Yes.
you can move your application. But if you want to file, if you say you want to file something in relation to the contract affidavits, which will be on file then, it's a different.
No, it's on law. I have copies here.
But if it's
I have
on law,
copies.
if it's on law, then move the application.
Maybe some points of law. Go ahead.
Move the application, he will reply.
He will reply. So that we can go on.
So you have the option. Let's understand what you want.
Yes, my lord, I'll take the hint of the tribunal in order to save time and
What do you want to do? Not our hint, what do you want to do?
no, I would like to of us proceed.
So move the application.
Yes. Yes. Mr. Chairman. Yeah. Before this honorable tribunal, we do have a motion on notice. Brought under the hearing registration of this honorable tribunal. And
Why was that motion dated?
the motion is dated the 25th day
5.
of May, dated and filed on the 25th day of May 2026.
May. Let's see then.
It's March.
March, sorry.
March only.
Let's see this.
My lord, this matter is not.
We are not ready, just complete.
I'm even meeting up documents. That's the challenge I have.
I saying okay, you want to do?
Who can move with no? My learned friend on the other side there. Why you met him physically?
Don't bother yourself about your learning.
It's your case. So we can.
Mr. Chairman, sir, I'll crave the indulgence of the tribunal. Let's just take a date so that we'll tidy up all these loose ends. And I will appeal to my learned friend. He's a gentleman when you meet him in person. I'm appealing to him. Please just let's have one day. Let's put this whole thing in order. He's a gentleman. We don't have issues. When we met him, we're very cordial.
Where did you meet?
We met at the High Court.
Where?
In
Abakaliki?
No.
No,
in Bayelsa, the High Court. We met at the High Court.
So we are friends.
No, we are friends. We are friends. We don't have issues. He cannot deny that.
He has not said you have issues. Let's address he has not said that you have issues. You say you want a date.
Yes, that's
You sound about
we humbly apply to this honorable tribunal to grant us a date. Let's put everything in order and come back and do the needful. I believe that by then all the rulings might even be ready.
one.
Yes, Mr. Chairman. Mr. Chairman, while I confirm that Mr. Gare is my friend, I will also highlight the point that the appeal in itself is not friendly and is unlawful.
Let's not go to the merits of the appeal.
Yes, sir.
He has applied for a date.
Yes, sir. We are vehemently opposed to the application for a date. And
We're
inclined
to grant him the adjournment.
My lord, it should be on terms. My lord should consider that this is a case between government.
Make your solution.
My lord, we are saying that the tribunal should appreciate that this case is a case between government and an individual. Government has all the resources of all the taxpayers to dispense on anything, whether rightly or wrongly.
Government have all the resources for it.
Of all the resources pulled from all the taxpayers, including the appellant, including the respondent rather, to dispense on anything rightly or wrongly. Whereas the taxpayer in Nigeria provides everything for himself, including security. Which ought to be the primary duty of government.
Primary duty of Bayelsa State government or federal government?
My lord, it's the duty of both the Bayelsa State government and the federal government. Government is government. Section 14(2)(b).
You don't have electricity?
My lord, the owner of this business was kidnapped. He paid ransom. It is stated in the letter we submitted to them. The owner of this business is using solar to do his business. The owner of this business is using private security. Yet government is taxing him.
Oh, no, that is okay.
Yes, in doing all this, government is not also ready or prepared to do what they ought to do at the right time.
I think you have been selecting those issues in the wrong forum.
That's a justification.
But Lord, we ventilate it everywhere, especially where it's in fora like this, where government is asking for protection or asking an institution created by the same government to help it collect from the citizen. They should come by due process. And when they make mistake of due process, they should not be indulged. That is justice. Everything about fair hearing has been destroyed in this matter, right from time, service, facility, and time to do matter. They have abused it. Government has abused it. There's no cause of action even. And we made that point, and the tribunal has not determined it. Yet we are hearing avalanche of applications to amend. If we succeed in amending a process that has no cause of action, as we stated in the preliminary objection, what would the tribunal decide after all? There's no demand to this tax that is before the tribunal. Those are the issues the tribunal will look at.
All the your talk on the responsibility of government and all that, is that the reaction to the appeal for adjournment?
Our reaction is that government should give us 500,000 naira costs. If they're not ready to go on today, the appellant should give us 500,000 naira costs. They've taken a lot from me. And they're enjoying what they are doing because this is the intent of the appeal was to punish the respondent. Ab initio. There's no case. If they continue to drag it, we'll continue to spend money. The tribunal should come to our protection.
Oh no, you have not incurred any expenses.
I have incurred. My lord, every day my diary comes with money. Any day I sit down here and wait for the tribunal, I'm losing money elsewhere. My client is paying me. Every day I sit down and listen to and join the tribunal, I'm using data provided by me, not by government. I'm using a reliable power supply provided by me, not by government. If I rely on government, I will not be able to conduct these virtual proceedings. Yes.
Does the court come to council or to the discuss?
Sorry, I didn't hear Mr. Chairman.
The cost you are asking for, does it go to you or to your client?
My lord, award of costs is in favor of my client because he is the one paying for the cost I'm bearing. It's in favor of my client. All these things I've enumerated, he is the one paying.
There's nothing to reconcile. Okay, on the cost. On the cost. Okay, I got it.
Yes.
Costs.
Yes, my Mr. Chairman and honorable members of the tribunal, we are vehemently opposed to the application for costs.
Then go on.
Mr. Chairman, the general principle of law is that cost follow event. Mr. Chairman, this matter is a matter that is being heard virtually. If any, at almost no cost to the respondent, except for that of, at almost no cost to the respondent. The respondent in this matter is not even a company, it's a business name, it's a business. It's an individual who is not present here in court, in this tribunal, has never been present in this tribunal. Mr. Chairman, the reason sought by counsel to the appellant for this adjournment is not frivolous. It's not frivolous, and it's also in the best interest of justice that the adjournment sought be granted. Such that such that we would have been able to put in our reply on point of law and put up a tidy arrangement to aid this honorable tribunal reach a just conclusion in this matter as to the issues in contention at this time.
Are you reopening your application?
No, my lord, I'm not opening any application. So I will appeal to my learned friend to, and also the honorable tribunal, to jettison the call for cost. Mr. Chairman and this honorable tribunal, we're most grateful. That's our humble application. Mr. Chairman, I just wanted to add.
Yeah.
Mr. Chairman, it is on record in this honorable tribunal that where the issue of cost arises as a matter of fair practice, I personally concede to those things. It is on record in this tribunal. I've considered to cost even where we should have maybe opposed.
In this case?
No, not in this particular case, but simply for instance. Yes, in other matters, I have considered to cost. Personally, because I believe I should treat my colleagues fairly also. I've considered to cost. It's on record.
Mr. Chairman, if I may respond on points of law, I will refer the tribunal to the case of Free One.
Which law did he cite? Which law did he cite?
He cited the law on fair hearing. He cited the law on cost following events. He said the law follows invent. I want to state the invent now and place it with the law that supports this as an invent. If a council could come to court and not ready to go on with his matter, and then say that there's no invent when another lawyer left what he's supposed to do and come and sit down and for hours, and then he said there's no invent. I don't spend my time that way if he does. For me, time is money. And the court has appreciated that too, especially with my rank as a lawyer of my years of calling.
What is in June? 18th.
Sorry, may I be guided?
What is in June? 18th or 16th? 16th.
18th is preferable. 18th. 18th is preferred.
16th.
No, you say 18th, don't worry.
18th, 18.
We are looking for adoption of our motion. And perhaps ruling if possible.
This tribunal is not inclined to award costs in the circumstances of this case. And will further adjourn this case to the 2026 for hearing of the motion on notice to amend the notice of appeal. One next time, if he doesn't do the case, we'll give it cost.
As the tribunal pleases.
Huh?
As the tribunal pleases.
Tribunal shall now rise, please.
Mr. Ogonu, my very good friend. I'm sorry.
Again. Hello. Hello. Can you hear me? Can you hear me?